Hi, I'm Antonia Mercorella, CEO of the Real Estate Institute of Queensland. As many of you would know, on the 14th of November, the Queensland Government passed the Body Corporate and Community Management and Other Legislation Amendment Bill 2023. The bill makes changes to several pieces of legislation that regulate community title schemes here in Queensland. It's important to note that these laws have not yet commenced. In fact, most of the changes will commence on a date to be fixed by proclamation. This means a future date to be set by Parliament. The changes relating to sunset clauses, however, will commence upon assent, which means they will commence immediately once the bill receives royal assent and becomes an Act of Parliament. This may occur before the end of this year, and of course, the REIQ will keep you updated about when all of these changes are expected to commence. Again, it is important that when real estate professionals are speaking with clients or prospective clients, that you are very clear that these laws are not yet in force, and please be careful not to make representations that these changes are law today. So, what are the changes? Well, there have been changes to provisions that regulate how community title schemes are to be terminated, pets, smoking, and of course, towing. Let's take a look at scheme termination first of all. Currently, community title schemes can only be terminated if there is unanimous support from all of the lot owners in the scheme. These changes provide that a scheme may be terminated with a 75% majority support on economic grounds. In summary, a scheme can be terminated on the grounds that the scheme is not economically viable or will not be economically viable within the next 5 years. There are a number of statutory steps and protections included, including a pre-termination report, the need for a general meeting, and of course that majority resolution must be passed, and also the body corporate must develop a termination plan resolution, which requires the body corporate to prepare a termination plan containing some important information. In addition, the termination plan must provide some compensation for lot owners and also compensation for other parties with a particular contractual interest in the scheme. Of course, if a lot owner disagrees with the motion, there are consumer protection mechanisms available to them to dispute the decision, and that involves making an application for an order from the court, and that will be at the cost of the body corporate. Now let's move on to smoking. Under the new laws, body corporates will also be permitted to make bylaws that prohibit or restrict the smoking or inhaling of smoking products on both the common property, for example in barbecue areas, and also in the outdoor area of a lot. So this might include a balcony or a courtyard or a patio. Let's move on to pets. Body corporate bylaws can no longer implement blanket pet prohibitions or bylaws that prohibit the keeping of animals in a scheme or restrict the number, type, or size of animals that may be kept. Under the new laws, an owner or occupier may seek the body corporate's permission to keep a pet, and the body corporate must not unreasonably withhold such approval. Similar to the owner of a property under the Residential Tenancies Act, a body corporate can only refuse a pet on prescribed grounds. For example, if the animal would pose an unacceptable health risk to the health and safety of an owner, or of course, if keeping the animal would contravene some other law. The body corporate may also provide its approval and impose reasonable conditions in writing. And finally, towing. The law has been clarified to establish that there is nothing in the legislation to prevent a body corporate from towing a motor vehicle from the common property for the scheme if it is done in compliance with towing regulations. Now let's move on to sunset clauses, which was added at the 11th hour. So changes have been made to the Land Sales Act to regulate the use of sunset clauses within contracts for the sale of proposed lands, often referred to as off-the-plan contracts. Sellers will only be permitted to exercise their rights under a sunset clause to terminate an off-the-plan contract with the written consent of the buyer, or alternatively with an order of the Supreme Court. If a seller seeks to terminate a contract under a sunset clause, it must provide the buyer 28 days notice before the sunset clause, and there is an obligation on the buyer to respond and act reasonably. It's also important to note that these provisions will apply retrospectively. Now again, we will be putting out more comprehensive information about this. And as always, we have created a new fact sheet for our members in the real estate profession, setting out these changes in detail and providing important best practice advice. Take a look at that in the member resources area of our website. And finally, for all of our members, if you are wanting more advice about this or any other agency practice issue, please contact our friendly team here at the REIQ for more advice. Thanks for listening, stay safe, and we'll see you next time.